Good morning, ladies and gentlemen. As Judge Johnson just explained, the state has the burden of proof in this case and in every criminal case. And so that's why I'm going to have the chance to talk to you first, then the defense will have the chance to give a closing argument, and then I'm going to have a chance to talk to you again. First, I'm going to address kind of the boring stuff, or what seems boring, but it's really important, and that's the law that applies to this case. Again, we have the burden of proof. We have to prove each of the charges beyond a reasonable doubt, and that is a burden that the state gladly welcomes, and that is imperative to the criminal justice system. And I know that you all have seen on TV and know that the state has to prove each of the elements in each of the charges beyond a reasonable doubt. Not turned on here this morning. Well, what does that mean? Beyond a reasonable doubt, it sounds like such an ambiguous term. But as Judge Johnson is going to instruct you in a few minutes, a reasonable doubt is the doubt of an impartial juror honestly seeking the truth. You know, when we questioned you during voir dire at the very beginning of this trial, one of the reasons that we asked you many of the questions that we did about your background and about your experiences is to make sure that each of you would come into this trial without any biases, as impartial jurors, and that you would come to a verdict not based on your past experiences, but based on what you've heard in court over the past couple of weeks. And we thank you for being here and being those jurors. But Judge Johnson is also going to instruct you that reasonable doubt is based on common sense. It's based on reason. And that is really the second thing that we were trying to learn when we questioned each of you at the beginning of this jury trial. And as I mentioned in opening statement, after trial, I've been practicing as a prosecutor for 16, 17 years, and after every trial, I get calls or I get approached by jurors, and they always say, why? Why did you put me on this jury? And there's no specific reason, no specific answer you gave that is the reason that you're here. The reason each and every one of you is here is because you all struck me and Mr. Emmons as folks who would use common sense when listening to the evidence in this case and deliberating and coming back with a juror. So thank you for being those kind of folks, and thank you for being here. And I'm going to ask that you follow the law and use common sense and view the evidence through the lens of reason and through the lens of common sense. Now, reasonable doubt is also not certain things. It's not to a mathematical certainty. The state does not have to prove the charges to 99, 100, and 110%. It's also not beyond all doubt. And I'm going to go a little bit further into that in a couple of minutes, but there are always going to be doubts because we can't videotape every single murder and every single criminal incident that occurs in DeKalb County. So you're always going to have questions in your mind. Reasonable doubt is also not a possibility. And you are not, as jurors, to go out and look for doubt. Reasonable doubt means that if you came in here with an open mind, not knowing anything about the case, and after hearing all of the evidence and looking at all of the exhibits, you believe that the defendant, Richard Merritt, committed each of these crimes. If you reasonably believe that, then you can and you should convict. My favorite way to think of reasonable doubt and what beyond a reasonable doubt means is to think of it like a puzzle. When you sit down and you start putting together one of those gigantic jigsaw puzzles, you may start at the edges and work your way in. You're gonna get to a point where you see something like this. There are pieces missing. There may be questions as to what color the eyes are or how many teeth this guy has. But because each of you is a reasonable person, you are able to look at what's there and say, yes, that's a tiger. And you know that beyond a reasonable doubt because you can put the pieces together in your mind based on what you do know about the case and the facts that the state has presented. That's just like a criminal case. You know, I don't know, and nobody will ever know, the conversation that Shirley Merritt and her son had before he murdered her. We're never gonna know what clothes he was wearing that day or what he did with Shirley Merritt's cell phone. But what we do know are the facts that bring us to the proof of the elements of each of the charges in the indictment. We don't have to prove all that extraneous stuff. All we do need to prove by law is the charges, and we're gonna go over those in a couple of minutes. Additionally, there are things that are not required by law when you render a verdict. The first is scientific proof is not required, and I am certain the defense is going to hammer home how there was no DNA evidence that proved that the defendant was holding that dumbbell. There were no fingerprints on that knife that proved that the defendant was doing the stabbing at the time of the murder. But none of that is required by law. In fact, the law recognizes how difficult it is to get scientific evidence. And you all heard from witnesses that this ain't CSI. Alexandra Jason, remember her? She was the DNA expert from the GBI crime lab. She testified that she tested the DNA that was rendered from the hairs that were found in Shirley Merritt's hands, and all the hairs that could be tested positively were matched to Shirley Merritt. And she also testified about that dumbbell. Yes, they were able to obtain a swab. There was DNA on that dumbbell, but there wasn't a sufficient amount to come to a conclusion. She said, yes, there was DNA, but because there was so little, we couldn't determine who that DNA belonged to. Now, that doesn't mean that DNA did not belong to the defendant. It just shows that it's inconclusive. And you know what Ms. Jason said that was really important? She said, the crime lab really doesn't like to test for contact DNA because it is so often inconclusive. It's so rare that we get that kind of result, especially when we're dealing with a metal object like a dumbbell or a plastic object like a knife handle, and not something like clothes where skin cells would get trapped and stay. The law does not require forensic proof. Again, we go back to those fingerprints, and as you heard from Jesse Worley, the fingerprint expert, not every item is conducive to containing latent prints. A plastic item that has some texture, like the knife handle, it just doesn't always hold on to those skin oils that would leave the latent prints. Same with the dumbbell. Because it was textured, it wasn't something that was likely to produce a latent print. Now, that doesn't mean that the defendant didn't have his hands on those items. It just means that there were inconclusive results, which is what we expected and which is okay because the law doesn't require these things. Finally, the law does not require an eyewitness to have seen the incident. The law, again, recognizes that when you've got a murder that occurs in somebody's home, there's usually not going to be somebody who sees what happened. These are the kinds of crimes that occur in private. And we're going to talk a little bit more about eyewitness testimony in a couple of minutes. But first, I want to go over the charges in the indictment. As Judge Johnson read to you, there are several charges. They are felony murder, 2 counts of felony murder, 1 count of malice murder, 2 counts of aggravated assault, and 1 count of possession of a firearm during the possession of a knife during the commission of a felony. Those are the charges against the defendant, Richard Merritt. And I want to go through each of them because it's the elements of each of the crime that the state has to prove and nothing else. And the first charge that you will see when that indictment comes back to you and you all are deliberating is malice murder. And the elements of the charge of malice murder are that the defendant did unlawfully cause the death of Shirley Merritt with malice aforethought. That's all we have to prove for you to find the defendant guilty of that charge. It sounds pretty simple, doesn't it? But what is malice? Well, Judge Johnson is going to read to you that malice is the intent to kill without justification, excuse, or mitigation. It is not necessarily ill will or hatred, and it does not require a proof of motive, because we can't read the defendant's mind at the time that he bashed his mom's head in. It does not require that we prove premeditation. This isn't something that he had to plan during the course of the day or even hours or minutes before the murder occurred. Malice and the intent to kill can be formed in an instant. He didn't have to have malice the morning when he woke up. He didn't have to have malice while his mom stood there making his spaghetti. When the defendant made contact with that blade to his mother's skin, that's when we have to prove that the malice occurred. And again, we can't read the defendant's mind. We don't know what he was thinking when he committed these offenses. And the law, again, recognizes that, so that it allows for malice to be implied. You all can imply malice existed based on the circumstances of the murder and what happened before, during, and after he killed Shirley Merritt. It can be applied when no considerable provocation appears. You didn't hear any evidence that poor 77-year-old Shirley Merritt provoked this murder. When the circumstances show an abandoned and malignant heart. That's actually what the law says. An abandoned and malignant heart. During this trial, you did get to see some photographs of the crime scene and of the autopsy, but out of respect to Shirley Merritt and to her family and friends who are sitting in this courtroom, I didn't publish all of those. But I will submit to you that when you go back into the jury room and you see the photos of what this man did to his own mother's face, you will find malice. Look at Exhibit 28 and look at Exhibit 62. Those are photographs of what malice looks like. Proof of motive is not required. Again, we're going to talk about what the possible motive is in a few minutes, and I'm going to go over it with you. But the law recognizes that we can't read the defendant's mind. We don't have to prove what he was thinking. We just have to prove his actions. As to counts 2 and 3, the defendant is charged with felony murder. And to prove felony murder, the state has to prove that a person commits murder when, in the commission of a felony, that person causes the death of another with or without malice. So basically, the question is, did the defendant stab his mom with a kitchen knife? And in doing so, did he kill Shirley Merritt? And did he bludgeon her in the head with a 35-pound dumbbell? And in doing so, did he kill her? Again, we don't have to prove premeditation. We don't have to prove motive. All we have to prove is that he committed those actions. Aggravated assault. It's charged in counts 4 and 5, and we've charged it 2 ways. Aggravated assault is when a person commits an aggravated assault when he or she assaults another person with a weapon, which, when used offensively, is likely to or does cause serious bodily injury. Well, the serious bodily injury shouldn't be a problem, but we've charged this 2 different ways. First, that the defendant committed aggravated assault against Shirley Merritt with a knife, and second, with a 35-pound dumbbell. Again, motive is not required. Premeditation is not required. Only that he committed these acts, that he assaulted Shirley with these 2 weapons. The last charge on the indictment, I'm not even really going to talk about because it speaks for itself. It's the offense of possession of a knife that is 3 inches or longer in length during the commission of the offenses previously charged. I anticipate that in a few minutes when the defense gets up here, they are going to talk about what kind of evidence we have presented versus what kind of evidence that we haven't presented. And they're going to make a big deal about how the state has met its burden of proof only on circumstantial evidence. And that's okay. The judge will charge you that there are 2 different kinds of evidence. The first is direct evidence, and the second is circumstantial evidence. Now, direct evidence, as the law states, is the testimony of a person who asserts that he or she has actual knowledge of a fact. Direct evidence, it's basically eyewitness testimony. And as I already explained to you, this kind of crime is not going to happen in front of an audience. It was the defendant who chose where to commit this crime. And it was the defendant who chose to commit it in the middle of the day when nobody else was in the house. So no, we don't have any eyewitnesses, but that's okay, because the circumstantial evidence in this case proves the offenses beyond a reasonable doubt. And Judge Johnson is going to explain to you that circumstantial evidence is a set of facts and circumstances that tend to prove or disprove another fact by inference. There it is again, that word, inference. Again, it all boils down to common sense. The law states you may use reasoning and common sense to make deductions and reach conclusions. So you can take all that you do know, from the crime scene to the timeline to the statements given by each of the witnesses, and you may make inferences as to the guilt of the defendant. And I will submit to you that all of that evidence is sufficient to make you believe that the defendant committed this murder. And that's enough to prove that he is guilty of these crimes, and that is enough for you all to render a verdict. By law, it's enough for you to render a verdict of guilty. There is no legal difference in the weight you may give either direct or circumstantial evidence. You know what that means? That means that you can convict on circumstantial evidence alone. So don't let the defense convince you otherwise. Again, the law allows you to convict the defendant of each of these charges by circumstantial evidence alone. The law also states that you will be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves guilt beyond a reasonable doubt. And there we go. Reasonable. Again, it all boils down to common sense and reason. You know, I like to kind of think of my daughter when I think about reasonable doubt and circumstantial evidence. I have a 4-year-old, and we have made it our Christmas tradition to build and decorate a gingerbread house every year. That's our creation this year. Clearly, we are gingerbread artists. This past year, we made a gingerbread house about a week before Christmas, and we put it on the kitchen table, made a big deal out of how it was going to be our centerpiece for Christmas morning breakfast. But a couple days before Christmas, I was home just cleaning, wrapping presents, whatever, and I came upstairs and I looked at that, and you see that kind of clump of gumdrops on the roof. There's like orange and purple and red. I noticed that those were gone. And there was a chair that was pulled out from the table, and there were some flakes of icing next to the gingerbread house. It didn't take me a long time to figure out what had happened. Clearly, because of what I know about my home and about my family and about the circumstances, my daughter climbed up on the chair and picked those gumdrops off of the roof of her gingerbread house and ate them. That's what happened. No question. Now, is it a possibility that my husband, who was also at the house at the time, committed that offense? Yes, but I just know him well enough to know that he is not going to eat the 5-day-old gumdrops that are sitting on the top of a nasty gingerbread house with gross icing on them. Is it a possibility that when I open the sliding glass door that you can kind of see that's behind that, a squirrel ran into the house without me recognizing it, and it climbed up the table and it got the gumdrops and took them outside and ate them? Sure, it's a possibility. But is that reasonable to believe? No. Is it a possibility that 2 armed men, one tall and thin and one short and pudgy, came into the house with guns and picked those gumdrops off the roof of my daughter's gingerbread house and left without me seeing? Sure, I wasn't in that room the whole day, but is it reasonable to believe that? No. Based on what I know about all of the circumstances of that day, I know that my daughter took those gumdrops and ate them, and I don't need fingerprint evidence, I don't need DNA evidence, I don't need an eyewitness to know that. When the defense gets up here in a few minutes, I would ask you to remember that gingerbread house, because this case is just like that. You all know the circumstances of this case, and you all are reasonable people. So think, when they talk to you, is the story that they're gonna tell reasonable? What is reasonable to believe? And we're gonna talk about that when I get the chance to speak to you after the defense closing.